which above the 70-degree azimuth close the projection of our Atlantic facade to international waters, thus cutting off our territorial sea rights, contiguous economic zone, and continental shelf. In this sense, it is important to remember that, according to the Venezuelan Constitution, sovereignty and territorial integrity are inalienable rights of the nation, Article 1, that the full sovereignty of the Republic is exercised in the continental and insular lake and river spaces, territorial sea, inland, historical and vital marine areas, and those included within the strait baseline adopted or to be adopted by the Republic. The soil and subsoil of this, the continental, insular, and maritime airspace, and the resources found therein, including genetic resources, those of migratory species, their derived products, and the intangible components found therein due to natural causes, and over the aquatic spaces constituted by the contiguous maritime zone, the continental shelf, and the exclusive economic zone, in which the Republic exercises exclusive rights of sovereignty and jurisdiction under the terms and Article 11 and public international law. And that, as a consequence, the Constitution declares that the mining and hydrocarbon deposits, whatever their nature, existing in national territory and under the bed of the territorial sea in the exclusive economic zone and in the continental shelf, belong to the Republic, are goods of the public domain and therefore inalienable and imprescriptible, according to Article 12. Hence, the express constitutional obligation of the Venezuelan state to establish an integral policy in the law, in the land, insular and maritime border areas, preserving territorial integrity, sovereignty, security, defense, national identity, diversity, and the environment in accordance with cultural, economic, social, and development and integration. This according to Article 15. The Academy of Political and Social Sciences has been consistent for many decades in studying the subject and informing the national community about Venezuela's rights over the territorial sea, in the exclusive economic zone, and in the continental shelf that projects the current Venezuelan continental territory on its Atlantic facade. Particularly, since a decade ago, the Academy has publicly addressed the authorities of the Venezuelan state through pronouncements, statements, and directly through communications to bring to their attention the importance and the need to defend the rights of Venezuela against the threats and aggressions by Guyana to our territorial integrity in its Atlantic facade, which can be consulted in our digital portal or webpage. Next, I will simply make a brief reference to the pronouncements of the Academy on the subject that concerns us today. Then, 1st of October in 2013, the Academy denounced Guyana's pretensions to delimit without participation of Venezuela its maritime areas to the detriment of the clear rights that correspond to it as well as its pretension to extend the outer limit of the continental shelf up to 350 nautical miles without taking into account neither the current rights nor the rights claimed by Venezuela. In its pronouncement statement made 9 days before the interception of the vessel Perdana, the Academy expressed its deep concern and the inexplicable silence of the national government in the face of the recent actions carried out by Guyana, which were in direct violation of the Geneva Agreement and to the detriment of the territorial sovereignty of Venezuela. The Academy warned that the inaction of the Venezuelan state and its abstention in the face of this new violation of national sovereignty by the government of Guyana could bring negative consequences under international law, for which reasons it requested the government of Bolivarian Republic of Venezuela to raise its most emphatic protest before the government of Guyana. This statement was endorsed by the Inter-Academy Committee of the National Academies, which was signed by several of its presidents. In second place, on October 22nd of 2013, in view of the interception by the Bolivarian Navy Oceanic Surveillance Patrol vessel, the Guyana, on the vessel Perdana, which was sailing in maritime space corresponding to the Venezuelan exclusive economic zone above the 70 degrees azimuth, the Academy pronounced, manifesting that the government of Venezuela cannot be satisfied with the isolated and plausible acts of the interception of the vessel, but it is also obliged constitutionally to urge the government of Guyana to revoke to the concessions granted in zones of the exclusive sovereignty of Venezuela and to formally express to it that Venezuela will not recognize any legal acts, any de facto situation of any country which contradicts its sovereignty over maritime spaces. On that occasion, the Academy concluded by urging the government of Venezuela to intensify the patrolling of the territorial sea and the exclusive economic zone of the Atlantic coast. In third place, on April 21st in 2015, in view of the granting by the government of Venezuela of the mentioned exploratory blocks and concessions to transnational oil companies on the continental territory under the claim and on the Atlantic coast, the Academy once again expressed its concern over the inaction of the Venezuelan state, as it could lead to negative consequences under the principles governing international public law, for which reason the Academy once again urged the government of Venezuela to raise its strongest protest before the government of Guyana. Fourth place, on July 29th in 2015, after the presidential address dated July 6th of 2015, and regardless of not sharing the totality of the political message expressed on the occasion, the Academy again made a public call and urged the government of Venezuela to take into account the need to clearly differentiate and affirm the defense of our sovereignty over the marine and submarine areas that are projection of our current continental territory, since it is the sovereign right of the country that does not depend in any way on the outcome of the claim of the Essequibo territory. In this sense, the Academy reiterated once again that Venezuela, as a state with an Atlantic facade, has exclusive sovereignty rights in the spaces of the projection of its continental territory in the territorial sea. Secondly, in view of the current development of the international law of the sea and the mechanism established then at United Nations level under the Convention of the Law of the Sea, the Academy considered that Venezuela should carry out a comprehensive legal and strategic study with national and international experts in order to determine the convenience for the Venezuelan state to ratify such instruments and participate in the respective multilateral forums to monitor, affirm, resolve, and consolidate its rights over these areas. Fifth place, on December 7th of 2018, a working meeting took place at the headquarters of the Academy between the Academy and the Special Mixed Subcommission appointed by the National Assembly for the Defense of Sovereignty over the Essequibo territory and its Atlantic facade, in which the scholars exposed, presented and shared the position of the Academy in relation both the lawsuit filed by Guyana against Venezuela before the International Court of Justice, as well as the situation presented by the violation of Venezuela's maritime sovereignty by virtue of the exploration activities carried out by Guyanese state concessionary companies in areas of undoubted Venezuelan jurisdiction. In sixth place, on January 13 of 2021, the Academy established its position in relation to the decision of the International Court of Justice dated December 18, 2020, by means of which it declared itself competent to partially hear the lawsuit filed by Guyana against Venezuela and the legal actions and strategies that Venezuela should follow to exercise its best defense. But on that occasion, the Academy also urged the authorities once again to defend Venezuela's sovereignty over the marine and submarine spaces and the continental shelf that are part of its territory. Therefore, it reiterated that the granting of oil concessions by the Guyanese government in those areas which are of indisputable projection of the Venezuela's continental territory makes necessary the actions of affirmation and safeguard of this, as well as other diplomatic and legal actions in defense of Venezuelan sovereignty. 9, and finally, on September 13 of 2021, reiterating and developing some aspects of the previous pronouncement, the Academy affirmed that being a matter of state, the choice of the most adequate path for the defense of the rights of Venezuela concerns all Venezuelans. Therefore, this must be done through study, strategic evaluation, dialogue, and agreement among all national sectors, without exclusions and without vetoes. Thus, the country must unite around the defense of its territory, for which it is necessary that those who exercise political power and who therefore have this historical responsibility summon the whole of society in a responsible, transparent, and depoliticized manner. To this end, the best national and international experts should be called upon to form the best suitable defense team in order to establish the most convenient legal, procedural, diplomatic, and communicational strategy for the country's interests. Thus, as we have seen, for the Academy of Political and Social Sciences, the defense of the territorial integrity of the country has been an ethical and historical priority, not only in the face of the historical dispossession perpetrated by the British Empire during the 19th century and the invalidity of the Arbitral War, but also in the face of the continuous violations by Guyana of Venezuelan sovereignty over the maritime territory of its Atlantic coast, expressed in its abundant and consistent doctrine contained in its conferences, statements, and other publications. Thank you very much. Thank you, Professor Carlos Ayala, for your introductory words in this important subject that occupies us today about the platform, the continental shelf. And we thank you that you have ratified the role that the Academy has had on this very important subject. Now I'll give the floor to Professor Josmar Fernández, who is a PhD candidate of Universitas de Venezuela, is Magister of Development, Global Management, and specialist in negotiation and resolution of conflicts in security and defense. She has been co-author of the book Rivers and Risk in Venezuela. We have to point out that Professor Josmar Fernández has, with 13 years of experience and professional trajectory in the Ministry of Foreign Affairs, with an expertise that is direct in the direction of borders and the Presidential Commission, and the delimitation of marine and submarine areas with the Republic of Colombia, among other subjects. Professor Josmar Fernández has many years of teaching experience on the university level as well. We thank the presence of the case of the scholar Fernández, who coordinates this cycle of conferences. He's also present. Is also present the secretary of the corporation, scholar Celis Gomez, and I also see Professor Januzzi, Salvador Januzzi, who is present as well. Professor Fernández has the floor, who has told us that has a connectivity problem, so we are all going to turn off our cameras while she presents. For this reason, we are not going to go live with her image to help with her connectivity issues. Good morning, everyone. I thank the invitation by the Academy of Social and Political Sciences. in conjunction with Universitas Fundación. In this opportunity, it corresponds to refer to the continental shelf and the maritime boundary between Guyana and Venezuela, which, according to a previous conversation with Dr. Jesús Ollarves, will be oriented to put the subject in context and outline some elements of analysis. In this regard, I believe it is appropriate to highlight 8 points of particular interest. First, the definition of what it is a continental shelf. I think we have lost connection with Professor Fernández. Let's wait to see if she can join again.
Está conectada en este momento, profesora Fernández. No la escuchamos.
¿Aló?
¿Aló? Ahora la escuchamos, ¿ah? Sí, ahora la escuchamos. Yo creo que
Disculpe, pero
vamos a escucharla.
We're still waiting for the professor to recover her connection.
Alguna presentación, pero vamos a evitarlo para ver si logramos la conectividad total. Adelante, profesora Fernández.
You have the floor, Professor Fernández. Yes, so, as we already know, the maritime and submarine areas are defined by the concept of distance. This comprise the bed and subsoil of submarine areas that extend beyond its territorial sea and all along the natural prolongation of its territory up to the outer edge of the continental margin, or up to a distance of 200 nautical miles, counted from the lowest tide line or from the basis lines for which extension of the territorial sea is measured in cases where the outer edge of the continental margin does not reach the distance. I think we have connectivity issues again. Professor Fernández.
No.
Ok. ¿Me escuchan?
Sí, sí la escuchamos.
We're still trying to reconnect again with Professor Fernández.
Ahora, adelante, profesora Fernández.
You have the floor, Professor Fernández. Please go ahead.
Déjenme mover un poco el internet a ver si de pronto así me pueden escuchar, hay una mejor conexión. ¿Me escuchan claramente en este momento?
Sí, la escuchamos, ¿no? La escuchamos. Sabemos que está haciendo un grandísimo esfuerzo porque...
We know that you are making a huge effort despite the limitations.
Continental,
As I was saying before, this comprises the bed and subsoil of the submarine areas that, to extend beyond its territorial sea, it does not comprise the deep of not the. In the case of the seabed and ocean floor in accordance with the natural law.
Creo que nuevamente se ha caído la conexión. ¿Eh?
We have lost connection again.
Profesora Fernández.
Professor Fernández, can you hear us?
Profesora Fernández. Sí, vamos a hacer lo siguiente, profesora Fernández, y perdóneme.
Professor Fernández, let's do the following. And
conexión o una mejor conectividad con nosotros, porque
if you could find a better connection.
Bueno, esto es lo que pasa cuando se va la luz en las casas.
Sí.
Ok, vamos a ver si aquí
no
acaba de hacer un cambio.
No intente compartir pantalla para ver si logramos
Ok.
mejor conectividad.
Try not to share screen to see if we can have a better connection.
En función a eso y tal como se
Well, so
le
according to this,
referencia,
and how I was talking before, once it is considered that the concept itself of what is a continental shelf, then we enter into the consideration of a second point with this, the importance of the geographical configuration of the area in question, how it is that geographical configuration of that space, and that we know as the Atlantic coast and Venezuela. And we could identify in this great space and water column 3 sectors that are of interest. The sector that corresponds to the Gulf of Paria, which is delimited by the delimitation of the Treaty of the Limitation of Marine and Submarine Areas between Venezuela and Trinidad and Tobago, and the protection of the Orinoco Delta in all its margin from what it corresponds what corresponds from the marine and submarine areas from point number 9 within that delimitation that was made. I think we lost connection again. We have lost connection.
No, tenemos graves problemas de conexión.
No encuentro la
Perdón, por
forma.
favor.
Sí, adelante, profesor Fernández.
Please go ahead, Professor Fernández. I will suggest that while we try to solve this technical problem with Professor Fernández, why don't we why don't we try to let the other speakers go first, and then we can try to solve technical issues at the very end. I will gladly accept, but the problem is that I don't have battery because of the power blackout. I will try to improve my connection later. Yes, please, let's do that, and I'll give the floor to Professor Jesús Ollarves Irázabal. Jesús Ollarves is Doctor in Law of the Central University of Venezuela. He's also a specialist in international politics and economic rights. And he has great experience in teaching in international law, in human rights, in both undergraduate and graduate universities, both nationally and abroad. He's director of postgraduate studies of the Universitas Central de Venezuela, and also member of the committee, specialist committee in international public law. He's also researcher in the Max Planck Institute in comparative public law in Germany. Professor Jesús Ollarves, it's an honor to have you with us, and you have the floor. Thank you very much, Dr. Fernández. Good morning. I want that my first words must be to the recognition to the Academy of Political and Social Sciences and Universitas Foundation for the organization of this very important conference about the continental shelf and the maritime boundary between Guyana and Venezuela. As it was mentioned by the scholar Carlos Ayala in the introductory remarks of this conference, this is a subject that has been trivialized by authorities and has only attracted the attention because of the effects derived from the lawsuit that Guyana has filed before the International Court of Justice. The limit of our presentation is to highlight the importance of the Atlantic facade and highlight the problems that surround the setting of the limits between Guyana and Venezuela, and then to mention what are the applicable law international standards, and that obviously it is related in grade on pros. Yes. The first that we must highlight is that the Atlantic facade is a vital space because through the Atlantic, Venezuela conducts more than 95% of its international trade. It serves also as contact and exit with the Orinoco Apure hydrographic system, which is the only geographical option for Venezuela's maritime routes to the oceanic spaces. This area has an extensive hydrographic network, and the mouth of the Orinoco River in the form of an estuary favors navigability conditions from the economic perspective as well. It has large oil resources, gas deposits, manganese, iron, and other metals of great economic value. And the extensive coastline facilitates the construction of ports and excellent conditions for fishing, especially in the deltic area. One of the main problems that I think is the most pernicious business of Guyana's granting of concessions. And it has taken a part of a transversal axis of this problem. Since the independence of British Guyana on May 26 of 1966, the policy of concessions has been a consistent part of the Guyanese strategy to assert its claims to make the best possible use of the subsoil forests and water sources of the Essequibo. So we can highlight different stages. In 2009, Shell, the company of the Netherlands, announced the acquisition of a 25% stake in the Stabroek block license to expand its operation in Latin America, while the Exxon Corporation in Canada acquired a 75% stake in the same block, without prejudice of other concessions that not only over oil, but also mining concessions that have been granted illegitimately over Venezuelan territory. The Roraima block was handed over in June 2012 to the transnational oil company, a US transnational oil company, but its concession had been kept secret because it is located in front of the Atlantic coast of the Tamarcuto state, which is incontrovertibly Venezuelan territory. Therefore, the conflict deepened as of 2015 due to the explorations authorized by Guyana and the successive discovery of high-quality oil deposits by the U.S. oil company ExxonMobil in the Stabroek block, already mentioned, located in the area of the Atlantic Ocean that enters into the territorial dispute. Until this point, because we must point out that even before the independence of Guyana, there's a position that we have identified in 1965 in our territory. What is clear is that Guyana does not respect the rules of international law, but it invokes them to its benefit before the International Court of Justice, but violates them specifically on its policy on the maritime frontier of the area and reclamation, with the granting of concessions, despite the fact that the Geneva Agreement is very clear in establishing that until a solution is found, no government may carry out or authorize economic activities in said territory. Now, apart from Guyana's concessions policy, the other problem to be considered is that Venezuela faces serious challenges in the international legal arena as a result of two arbitration processes on the maritime delimitations that affect the possibility of guaranteeing its access to the Atlantic Ocean. The first arbitration refers to the delimitation between the Republic of Barbados and the Republic of Trinidad and Tobago. This dispute revolves around an arbitration of the year 2006, in which it was established the international maritime boundary between the two countries through an equidistant line of 11 geodesic points. The problem for Venezuela is that the tribunal placed point number 11 on the same line that Venezuela and Trinidad and Tobago established as their marine and submarine area boundary in the treaty signed by these states in 1990. For its part, Barbados defends rights under point number 11, and in the year of 2007 offered an international tender to allocate blocks for the exploration and exploitation of hydrocarbon deposits that will be on the marine and submarine areas delimited and mutually recognized between Venezuela and Trinidad and Tobago. It should be noted as well that although Venezuela issued several diplomatic notes rejecting the delimitation, it did not present formal objections before the Commission on the Limits of the Continental Shelf to the Barbados submission. And on July 5th, 2011, Barbados submitted a second version of the limits of its what it's considered its continental shelf beyond 200 nautical miles, thus affecting Venezuela's maritime space. The Venezuelan government has not yet pronounced itself on this new submission. The other issue to consider is that Guyana and Suriname decided to settle the disputes before an arbitral tribunal that in the year 2007 decided the limitation that was made based on the construction of an equidistant line of 2 points located on the coast of the Essequibo. And in the same, it makes reference the zone of the Essequibo as the land border with Venezuela. The problem with this arbitration is that it is ignored the existence of the Venezuelan claim over the territory. And the Venezuelan government did not issue an official protest note on this matter either. Notwithstanding these considerations we have talked about before, for the years 2008 and 2011, Suriname and Guyana respectively introduced continental shelf extension requests before the United Nations Commission on the Limits of the Continental Shelf. And it should be noted that Guyana, once again, what it is an evidence is these aspirations and its permanent disregards this disregard for Venezuelans' claim over the Essequibo. On March 9 of 2012, Venezuela appeared before the Commission on the Limits of the Continental Shelf and objected to the information submitted by Guyana, arguing that it is inexplicable the lack of consultation on the part of Guyana due to the fact that in order to carry out the intended extension to 350 nautical miles, the maritime protection generated by the coast of Guyana Essequibo will be used, which, although Guyana does not want to recognize, is a territory that is in dispute with Venezuela and subject to the Geneva Agreement. Now, the most important standard that it must be reaffirmed about the effects that are derived of the aforementioned arbitrations is that the rules governing the Commission on the Limits of the Continental Shelf in Annex 1, Article 5, is that in the event of a territorial or maritime dispute, the Commission shall not consider or qualify the submission made by any of the states parties to that dispute. However, what is very clear from this action, it is once again evident that Guyana is trying to disguise the problem that exists with Venezuela, omitting its obligation to achieve a practical settlement of dispute. Another issue that should not escape this analysis is a problem derived by the Guyana's passivity in the face of organized crime. This is a very complex puzzle of complexities, because Guyana has for a long time served organized crime groups, especially pirates, human traffickers, and drug traffickers, who take advantage of its geographic location as a crucial transit point for cocaine heading to the United States and Europe. Today, it is undeniable that the Atlantic coast, stretching from Punta de Playa in Delta Macura to the mouth of the Essequibo River, organized crime attacks vessels with war equipment, such as AR-15 and AK-47 rifles, and also traffic drugs, strategic materials, and people. I want to highlight that this is not an invention or a chauvinistic attempt to defend the rights actions of Venezuela, but rather the US State Department's Counter-Narcotics Office has noted since 2014 in different reports that Guyana is a transshipment route for South American cocaine and heroin destined for the United States, and that the smuggling of methamphetamine precursors is also a problem. In addition, that the same State Department have advised from 2013 and in the claim zone, traffickers are attracted by the country's poorly guarded ports and intriguing river network, low security, sector capacity, and cocaine. And inconceivable events occurred in August 14, 2014, when Guyana's anti-narcotics unit and the Ministry of Defense found a semi-submersible vessel in a tributary of the Guayana River near the Venezuelan coast. The situation is not only has been identified in those reports of the United States government. The situation is so serious that the former Guyanese President David Granger himself stated that Guyana is sleepwalking step by step towards a narco state, and that drug trafficking is the engine of growth that is driving the country's economy. As can be seen, the effects of organized crime cannot be avoided in the territorial dispute and must be confronted with the tools offered by international law. Now, regardless of the applicable regulations in these cases established in the Convention on the Law of the Sea, the Convention Against Transnational Organized Crime and its 3 protocols, as well as the Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances, and that when you do detailed analysis and transversal analysis of those dispositions, most of them have a double nature, customary law and conventional law. It is imperative also to reaffirm which are those standards and norms applicable to maritime boundary delimitations, and which reach and content and limitations and also consequences must be known to seek a formal route for Venezuela to exercise its rights, its sovereign rights over the claimed area. This is why those standards that stand out of importance are the obligation to negotiate, the principle referred to that the unilateral limitations of maritime spaces are not binding on third states, the principle related to the treatment of an equitable solution, the principle that the land dominates the sea, the principle of natural extension and non-intrusion, and of course, the sacrosanct principle of proportionality. With reference to the obligation to negotiate, the International Court of Justice, in the judgment on the delimitation of the maritime boundary in the Gulf of Maine region in 1984, has pointed out that any delimitation must be must be done by agreement between the states concerned, either by direct agreement or, if necessary, by some alternative method, which must, however, be based on consent. According to this rule, states have the obligation to negotiate in good faith with the genuine intention of achieving a positive result. Therefore, and by the way, this principle have been violated by Guyana many times in the historical process that we have lived. Therefore, the parties are obliged to initiate negotiations, but also to continue them as much as possible with a view to reaching agreements. On the principle that unilateral delimitations of maritime spaces are not binding on third states, the International Court of Justice itself, in the fisheries case in 1951, declared that the delimitation of maritime spaces always has an international aspect. It cannot depend solely on the will of the coastal state expressed in its internal and domestic law, and it is not binding on third states. With reference to the objective of achieving an equitable solution in establishing a maritime delimitation, appeared for the first time this standard in the Truman Proclamation of 1945, and since then it's become customary law applicable to all maritime boundary delimitations. It is a principle that it has been confirmed by the jurisprudence case law of the International Court of Justice, in the case Jan Mayen of 1993, among others, when it stated that the reference to an equitable solution as the purpose of any delimitation process reflects the requirements of customary law with respect to the limitation of both the continental shelf and the exclusive economic zones. Similarly,
que existe una distinción entre la delimitación basada en normas jurídicas y las delimitaciones realizadas por los estados mediante negociaciones, que obviamente entrañan, entre otras cosas, consideraciones de naturaleza política. En las delimitaciones basadas en normas jurídicas es oportuno precisar que la Corte Internacional de Justicia y los tribunales arbitrales han interpretado siempre que los criterios y factores equitativos pertinentes aplicables a la delimitación de fronteras marítimas significan directamente pertinentes a la operación de delimitación y por lo tanto no tienen carácter ni político ni económico. En este mismo orden de ideas hay que considerar el principio de que la tierra domina al mar. Y sobre este principio, la Corte Internacional de Justicia
this principle, the International Court of Justice, in the case of the Continental Shelf of the North Sea of 1969, among other decisions, is affirmed that the land is the legal source of the domain that a state can exercise at the projection to the sea. To the effects to evaluate the delimitation line, we have to take into consideration the criteria. And this is a standard that is fundamental. It's very, very important to have it present, because this criteria was mentioned by the International Court of Justice. In the same case of the Continental Shelf of the North Sea of 1969, and in which it was held that the delimitation of the continental shelf must be done in a way that it assigned each one of the parties as much extension that it could be done of the continental shelf, and to give a natural prolongation of the territorial source.
De la misma manera,
vayamos viendo el tiempo, profesor Ollarves.
Sí, por favor, quisiera que me obsequiaran 3 minutos para concluir.
Yeah, I would like to be given just 3 more minutes to conclude.
De esta manera también resulta muy importante
In the same way, it is equally relevant the principle of proportionality. This rule is often applied by the International Court of Justice in order to remedy inequitable results produced by geographical features, such as certain degrees of concavity or convexity of a given coastline. Thus, these aforementioned principles are the ones that the judicial or arbitral body must take into consideration when delimiting the continental shelf between Venezuela and Guyana, and are precisely the ones that should be taken into consideration that in the way of elevating any strategic options to the conflict. And also in the course of the negotiation process, states have a wide margin of flexibility in seeking to influence the outcome of the negotiations in favor of their rights and interests. And we always seek to use all factors they consider appropriate for the construction of the line or lines they believe to be equitable and satisfactory. But we believe that the case law standards set the way that not only the good law imposes, but also to find a satisfactory and equitable solution. By way of conclusion, we can point out that although the limitation with Trinidad and Tobago guarantees to a certain extent the Atlantic projection of the Venezuelan continental coast, the maritime delimitation will depend on the solution found to the territorial claim. Venezuela, we consider, must insist on the Atlantic projection of its continental landmass to allow it a direct and uninterfered access to the Atlantic Ocean and respect to the limitation made with Trinidad and Tobago. Venezuela should take more offensive actions should be taken to increase the perceived investment risk for new energy companies wishing to start operations in the area. The effective control and exercise of sovereignty over this maritime space in the long term will depend on the resolution of the disputes generated by the arbitrations on maritime delimitations between Trinidad and Tobago and Barbados, as well as between Suriname and Guyana. And there is something that we consider it is vital, in which has been mentioned before in other of this conference, that in view of the government's refusal to appear before the International Court of Justice, it is essential that we find a way for the court proceed on its own initiative to order provisional measures in accordance with the powers conferred upon it by Articles 41.1 of the ICJ statute and Article 75 of its rules of procedure in order to avoid further damage and aggravation of the situation. This is not a triviality. The reality is that Guyana is de facto in possession of the disputed territory, granting concessions to transnational corporations, exploiting natural resources, damaging the environment, destroying biodiversity, and creating conditions for drug trafficking and organized crime to operate. If provisional measures are not issued, the conflict will worsen, extending to the consequences derived from the exploitation of natural resources by the plaintiff in this judicial proceeding, and extending to areas that were not originally in dispute, as is the case of part of the maritime zone corresponding to the state of Delta Macura. I apologize for exceeding the time limit, and I'm very grateful for your attention. Thank you very much. Thank you very much, Professor Ollarves. You have taught us very much. You have talked about the strategic importance of the Atlantic facade to Venezuela, as well, very illustrative about the politics and actions of Guyana on this subject of the continental shelf. And it will be a privilege your giving suggestions, especially in these last sections, to the management of the actions of our country. Thank you very much, Professor Ollarves. Now we give the floor to Vessel Captain Pablo Cohen, who is an officer graduated of the Naval School of Venezuela, licensed in naval sciences, and other office graduated in the School of Submarines of the Republic Federative Republic of Brazil. Captain of Vessel Pablo Cohen Celis has been commander of multiple military vessels and office of submarines, has training in in the War School of Venezuela. He's also researcher of the border controversy of Venezuela, and is member of movement of rescue of the Essequibo. He has published on the subject, and one text that called my attention, a text for kids. Her books that is called Knowing Our Essequibo. Also, a publication of the Essequibo Sea in the context of the Geneva Agreement. Captain, you have the floor. We have a time of around 15 minutes. If you could please open the microphone.
No sé si nuestros amigos de Universitas, por
I don't know if
favor.
our friends from Universitas Foundation, could you please support Captain to open the microphone?
No, todavía no está activado, ¿no?
We're still waiting for Captain Cohen to open his microphone.
Todavía no. Señora Montero, ¿es posible que usted lo active desde su plataforma?
Debe activarlo el doctor Cohen.
Debe activarlo el capitán.
Viendo una notificación.
Ahora sí. Ahora sí lo tiene. ¿Eh? Adelante, capitán. Gracias por su intervención. Creo que se congeló la imagen. ¿eh? Hemos tenido...
We are having some technical issues at the moment.
Qué lástima. Capitán.
We're waiting for Captain Cohen to recover his connection.
Conexión, capitán.
I think he's having also connection issues.
Si se vuelve a conectar, vamos a intentar nuevamente. Vamos a esperar que él se vuelva a conectar.
Let's wait until he can connect back again. We haven't had any luck either with Professor Fernández. There's been a power outage at her house, and then she hasn't had electricity during the whole morning. But we are still attempting to reconnect with Captain Cohen Celis. Captain, I hope that we have the pleasure to hearing your presentation. We have you on the screen, but please open your microphone. If you like, we can stop video.
Micrófono abierto.
Y tiene ya
Please go ahead. And you, yes, perfect. You have also shared a screen.
Okay. Bueno,
Good. I will first want to thank Héctor Faúndez, who is the one that had invited me to participate in this very important conference. Dr. Gerardo Fernández did not mention that I belong to the movement Amigos de Esequibo, or Friends of the Esequibo, for many years. And I have a very good appreciation and understanding of the problematic. So I will want to mention something before to get into the subject, that we are various of us that we have an appreciation and understanding of a solution outside the legal scope, understanding of the people that is living there, but also from the people of Guyana themselves that need us. And that is the way that will lead us in the future, not at this point, because at this moment, the oil ambitions from the United States, from Canada, and other nationalities will not allow it. But in the future, they will get to us. I want to start this presentation of the continental shelf. I wanted to start with a definition of continental shelf. I want to talk technically of what we can consider as a continental shelf. If you are seeing the graphic, yes, please. We're seeing perfectly. Go ahead. So there, simply, I like you to see the left-hand border, what it says, exterior border of the continental margin. Until then, today, the legislation of the sea allows, that is the shelf not as shown in that drawing, but the continuation of the submerged continent up to the abrupt drop in depth called the continental slope. Until what we call, but we'll move fast through these graphics. In the purely geographical definition, until the 45 that Professor Ollarves mentioned, talking about the President Truman, it was established how to exploit that platform beyond the territorial sea. That in the 45 it was 3 miles. So in this case, from the hydrocarbons, and it was established as a maximum depth of that platform, of that shelf, until the 200 meters of depth. This is, I'm saying this because there's a lot of literature, a lot of books that still they're still circulating that are saying it this way. And we have to be careful because this changed completely already. And I'm going to talk about the 200 meters because it's a physical problem, because after the 200 meters, 220, this is where the continental slope normally begins, which we call the approach. And at the end is the beginning of the slope, and they will start to flow all the sediments as well. We deposited there, and it will create and I want to advance this because this process has to do with the definition of the continental shelf. Now I'll go to a legal definition, which is what appears, fishing zones and all that. It is consecrated to all states. They have guaranteed 200 miles of exclusive economic zone, and that could stand
Ahora bien,
only guarantee the 200 miles horizontally. So the continental shelf extends to the exterior border is being defined in a clear way in Article 76 of the Convention of the Law of the Seas, and it reaches until the distance between the slope, the ending of the slope, until the 1% of the sediments. Until then is where the continental shelf reaches. So if that conflicts with the exclusive economic zone, but now if that's reached beyond that sector that we are seeing right now on screen, as an example, I will put you as a classical example of this. The profile, the profile of the continental shelf. We have an extension that, but we have not reached still, as you have seen on the graphics, to the end of the slope that is much lower. But what happens? That we have maximum allowed extensions by the law of the sea. The first are 350 miles nautical miles, or, and this letter is very important in the text of the article, or 100 nautical miles from the isobato of the 2,500 meters. The first that it appears until then is the reach of the extension of the continental shelf. Until there is, there's no way to reach for any country of that sector to 350 miles. Because what it shows first is the 100 nautical miles, which is the mark of the 2,500 miles. That isoda is within the 200 miles of the exclusive economic zone. So what happened? We have extend 100 nautical miles more because we don't reach even to the 280 nautical miles. That's simply so you have a reference of the characteristics of that zone for us. I want to make reference to the very famous treaty that it was mentioned by Carlos Ayala. Jesús Ollarves also mentioned it. Professor Fernández was also going to mention it. That we signed it in the year of 1990. That a very few people has called its attention why that equidistant line that we marked it stopped in point number 20. And it was thrown away 6 miles to the north to reach point number 21 and continue until point number 22, where there is the exterior border of the continental margin in that point specifically. So what happened there? Well, that if we continue to the point number 20, we'll reach something called the Trinity Point, Trinidad, Venezuela, and Guyana. And what is it? That is why the Dr. Isidro Morales Paul, the chief of the delegation, to get up the line up to then mark that line onto the other point. Now we are accepting that Guyana is present there. And we're going to move a bit forward in the exterior border of the continental margin. It is there in the point number 22, but who is it from? And when I say who, because that same article 2 of the treaty, Trinidad and Venezuela talks about that we cannot affect any third state. And there evidently we were affecting Barbados. And you will say, then what happened there? But we need to find another way to not affect this. And it passed 12 years passed. And then after 12 years, Guyana and Barbados claimed, and many specialists said that they already missed out because after 12 years, you could get caught by the stopper principle. But we're now going to see another case that happened in 1991. Once we signed the treaty in the year of 91, Guyana, utilizing the rules of the law of the sea, marked its economic exclusive zone on 200 nautical miles, so that it appears with Venezuela a line from Punta Playa in the 0 to, and so people will ask, like, who is, we are adjusting to what is established by the law of the sea, and since they are from Punta Playa to currently establishing the economic exclusive zone. So what Venezuela said in 91, nothing. Venezuela remained silent. So there is Punta Playa, and I will present you Punta Playa there. And there appears the 200 nautical miles of exclusive economic zone that Guyana attributed itself. And logically, in that same year of 91, they started to openly establish these concessions adjusted to its exclusive economic zone. But I want to go to the year 1900 in the island of Corocoro. Not many people know that is important component of the river flowing of the Del Orinoco. It has an extension of 5 miles to Margarita. It's just a comment for you have a reference of what's going on. Well, in the straight line, there will with a second point to the under Barima River, and then the openings of the river Aroa, and then the mouth of Amacuro, and then the limit got.
Sino hablar allí de qué es Punta Playa.
Just only to talk about that is Punta Playa. Punta Playa in year 1916, it was again conform a binational commission between Great Britain and Venezuela, because in that year the sea destroyed that point. By then, in year 1916, Great Britain achieved that Venezuela becomes part of the commission, and therefore not the recomposition of that point, but the point 1 to point 2. They place 29 points in 30 kilometers. It is for you to see the importance that is being given by Great Britain to that limit called Punta Playa, that it guarantees to the River Guaini to have a free opening, a free exit to Venezuelan territory, and it has also a connection to enter to Barima River, and then to enter to the mouth of Orinoco and Amacuro without any interference, because that was established in the Arbitral War, which is criticizable, questionable, but it is there. So you will say now, but from Punta Playa born the reclamation zone in year 2021, where you see and it says, where it says Mora Juana, it was established a military base, which is very important. Very important to that area. It's just a simple observation. That is a photo that I had honored to take of that point, the point number 4, but I don't know what name it is given now. Now, going back to year 1997, Venezuela marked an azimuth, seeing the situation that it was being presented. It marked an azimuth 70-degree as a suggestion of the Ministry of Foreign Affairs to let know the Ministry of Defense that we must guarantee and patrol that they have to patrol that point, and I suppose, and this I say it as and I suppose.
No sé si me están copiando en este momento.
Sí, lo estamos.
En ningún momento se le puso como. ¿Están copiando? Ok.
Sí.
En ningún momento se puso como.
In no moment it was this was declared in any decree statement. It was just for the purpose of patrolling. It did not have anything to do with the law of the sea. The morphology of the island of Corocoro in that sector doesn't allow, it's not a delimitation or even equidistant what it was marked by Guyana from Punta de Playa. In a delimitation, it was equidistant according to law of the sea. We went for that one, and not only we said we marked that line, and then it entered into force the Constitution of Venezuela in the year 2000. What happened with that Constitution? Well, that Punta Playa stopped to be conform part of the territorial part because we do not recognize the arbitration award. But what is it? It is then there wasn't anything explicit that it will say what was the delimitation of from the mouth of the Essequibo or the Monaco River. The Constitution didn't say anything. Even the Dr. Escarra, who was one of the constitutional drafters that prepared the Constitution, accepted and understood that they lacked an explanation, and this was the motivation of the custody organism that keeps utilizing Punta Playa as the territorial limit of the Delta Macuro state. What happened in 2002? Guyana and Barbados questioned the treaty between Venezuela and Trinidad and Tobago. But neither they could not question it because they've been in the files of United Nations for 12 years. But in 2003, Guyana and Barbados signed a treaty of joint exploitation of their exclusive economic zones. In 2004, after the declaration of the president in Georgetown that he was not going to get in with the problematic about the reclamation zone, this map that we see on screen, it was published, the International Mapping Association, where you can start to see that from the side of Venezuela, we continue to be 023, and you see already those concessions already marked there. Because why? Because they consider that forms part of the reclamation zone. I'm from Guyana. And since the Venezuelan government was not going to question it, then the map appeared publicly. In 2006, the International Tribunal for the Sea established the arbitral award to establish the border between Barbados and Trinidad and Tobago. They had an equidistant line and then opens a bit for the Barbados to reach the 200 nautical miles in that area of exclusive economic zone. But Trinidad and Tobago alleged that they had the right to reach point number 22, and it's been more than 12 years, and the tribunal denied the principle of stoppel, even though the people from Trinidad and Tobago patrol their area. Until that point, that point 12 could have a confluence in that same point.
Firmado Trinidad con Venezuela, pero no quiere decir que iba a respetar la continuación de la línea. Simplemente en el punto 11 y para abajo ya
Simply from the point number 12.
con Venezuela. El Tribunal Internacional en el
And then the International Terminal for the Sea in 2007 established the maritime border between Guyana and Suriname. You can see a little bit that actually reaches point number 20, a measure which is equidistant to Marina, and that gets an advantage point from Guyana to get mark. And this way they have talked before about the vessel Technique Perdana that was captured, not only captured, and taken to Margarita. The vessel reached to 135 nautic miles distance from Punta Playa and reached to Margarita. And since there, they were like around 3 or 4 weeks while a trial was opened to the captain of the vessel, and informed by the authorities, and the captain of the vessel was accused of violating the spaces of security maritime zones, and the tribunal accused it of, and the lawyers as well. This is very important. The lawyers of the company, in this company, asked the tribunal to explain if, asked the tribunal to demonstrate that was Venezuela. And the final result was that the captain was told, look, don't do it again. Just go away and don't enter that area. However, while that was happening in the tribunal, the ministers of foreign affairs were met. They met. The ministers of foreign affairs met around there in an opportunity that was going to, a delimitation was going to be made at that point according to the regulations of the law of the sea. And Venezuela accepted that within 3 months, that meeting was going to happen to make that delimitation and conduct that study. But then 3 months passed and nothing happened. In 2015, Guyana informed Venezuela of the arrival of the vessel. This is one of the huge vessels that are at the moment there, the Deepwater Champion. It was very, very, very close to Georgetown in waters that are from Guyana, but Venezuela protested profusely, but the proposal was directly with the ExxonMobil, not with Guyana. In that same 2015, they were created through a decree zones that belongs to the integral defense of maritime and insular zones. People that make that decree lack precaution in many points, and what they did was extending the line of the treaty from Venezuela and Trinidad and Tobago. They continued ahead until the 350 nautical miles and until the mouth of the Essequibo, and they reached to the 350 nautical miles, and would even cut off almost a half that the sea that belongs to Guyana and also from Suriname, and a great part of the sea that France has over the French territories that are there, and also took a part from Barbados. So obviously caused problems, caused commotion, but that decree lasted only 2 months. Up to 2 months, it was the decree was abolished. You can see where the Deepwater Champion was located, but once it was abolished, it was substituted by another one. And in back again to the azimuth 070. And that stayed as you are seeing on the screen. In 2016, marking ourselves the line of maximum aspiration from Venezuela, that you see that it cuts the big Starblock block, and has this name because that's the capital when it was Dutch authorities, and it's called Block Star. So you have an idea. So they went to Lisa Uno with a huge vessel. A lot that are arriving now, that you can see that it out in the Guyana Sea, and then it was accompanied from London, accompanied by. So this is what you have for you to have an idea. This is a huge installment as a form of vessel, but that cannot be moved even by storms. It's the only way to transport 2,500 to get to the maritime soil to keep exploiting oil. And what did the vessel do that to avoid piracy? It was accompanied by patrolman British, who was doing a courtesy visit in Georgetown, and the captain gave a declaration that you can see on YouTube, and avoiding that no one interfered with that vessel. In 2018, to go fast, see where the line is for the purpose of navigation and patrolling. In 2018, it was identified by a patrol 2 vessels in that position that you are seeing right there. It was ordered that they take the route of 095. And even you can see on YouTube the videos of those maneuvers. What did those 2 vessels do? They take the route 097. They cross the line, and there it is stopped. It was the Ramphone phase, which is a very huge vessel to bring information or how is the oil presence there, and a vessel support group, the Delta Monarch from the ExxonMobil group, and sponsored by Guyana's government. And it was in that case captured by the patroller Cariña, who requested to proceed immediately to cross that space. Well, so what happened in 2018? Venezuela will establish a decree that guarantee the exercise of the rights of sovereignty and jurisdiction, exclusive jurisdiction rights over the continental shelf that is protected by the Delta of Orinoco to the continental border. Well, that's okay. However, for it to reach the continental border, yes, because the decree in its first communication established, or in its first in the first considerandum, in the first provision, that according to the decree 1152 for the year 68, it was from that it was defined. That's the one that is marked in yellow, that get to the half of the Essequibo River. That's a decree that was marked in the year 68. 2 years. We were in the middle of the negotiation of the mixed commissions that were negotiating between Guyana and Venezuela. Regarding to the Geneva Agreement, they were saying that no positive results were achieved because the Guyanese and English,
trancándose a la banda de que Venezuela tenía que demostrar la invalidez del
which
laudo.
that Venezuela had to demonstrate the invalidity of the return to war, and the armed forces prepared to do a military takeover. That it was started by the General Pérez Jiménez in the year 52, that it was called Plan of Ayaurima. And the army needed to have a navigability space, at least that was able to circulate there. And I can, that the army prepared all the bridges that went through Pumeremo to Santa Elena of Guairén to have the appropriate roads to for transportation, and the Air Force conditioned the airport of Pumeremo for that to get all the planes, all military and non-military, for that incursion. There was all a series of movements that were getting done, and that's when that decree comes out. For that to decree that has entered into force in international law, we will analyze a bit further. Please, Captain, remember be mindful of the time. Yeah, actually, the time elapsed for a while ago, but we have let you go on. So that's more or less what it should be, the decree. But let's go to the next decree. It was created the maritime territory for the defense of the Atlantic Passage. So now it was created this decree for all an administration to try to administrate that decree. I'm going to talk about the decree of 1152. One of the problems I have that decree, there is a mistake of concept, because the first provision of the decree is based on the demarcation of a line of a straight line according to Article 4 and the following of the approval law of the Geneva Agreement. That law does not refer and is not about the treaties of straight line. I learned that about I learned that from some Guyanese friends with whom I maintain contact and exchange information. That's one hand, and then at the other hand, the decree violates the Article 7 of the Convemar, because it closed the territorial sea from the exclusive economic zone according to that decree. Where we are now finalizing now. Take a look at the companies that are operating now in that territory. The protection of the Delta of Orinoco is at the moment 4,500 square nautical miles. There we are patrolling at the moment, where you can see the yellow lines. In that territory, what is marked in line from the right-hand side is the maritime territory. It's the whole block of Starbuck, and there's all of those companies that you can see there. But we will have to see what decision is going to be taken about. But that is how the situation looks like at this moment. Sorry for the exceeding the limit, but thank you very much for your attention. Captain, you have given us all this practical knowledge and expertise around this topic. There is a question that I've been asked here in the chat. I mentioned that you elaborated a text for adolescents in the year 2016 that is called "Knowing Our Esequibo," where we can find that text. Well, unfortunately, at this moment, after being published, we are transforming it to a digital format so everyone can access it. So once we complete it, it will be available for all Venezuelans and Guyanese people as well. Well, I think that we So we finalize this event, very illustrative, and we thank Professor Carlos Ayala, Professor Josmar Fernández, Professor Jesús Ollarves, and Captain Vessel Pablo Cohen Celis. Unfortunately, we had the technical connection issue with Professor Fernández, but we cannot resolve it. We thank as well Mariana Escolaro Pereira for her work in interpreting simultaneously to English these presentations. And of course, we thank Universitas Foundation for the support, logistical support, technical support to bring this conference forward about the reclamation of the Essequibo territory. In charge and coordination of scholar Héctor Fernández Ledesma. Thank you very much, everyone, and we'll see you at the next meeting. Thank you very much. And we'll see you at the next meeting. Thank you very much. And we'll see you